Good day, Crime Talk aficionados. We have a great show for you today. First, say it isn't so. Did the FBI lie to us? The Delphi murder case in Indiana is getting closer to starting. Plaintiffs in the Murdaugh case settle when the attorneys realize there's no more money. Robert Tellis is sentenced and still claims that he's innocent. The Gilgo Beach killer case is going to come down to new DNA technology. Karen Reed gets some help from the ACLU on her briefs, and arrests for a missing woman whose remains have not been found. And should this woman get the death penalty for ordering her Rottweiler to attack a 9-year-old? We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket today, first, go to CrimeTalkSearch.com. Sign up for a background subscription service today. If you are bringing somebody new into your life, you need to check them out. I don't care if it's somebody going to be hanging out with your kids. I don't care if it's somebody in a romantic relationship. You need to check them out, and you need to do more than just a quick Google search. So when you go to CrimeTalkSearch.com, you sign up for that background subscription service, and literally you get a report generated while you wait. And you're going to get information about where they live, who their relatives may be, possible employment, their education, usernames that they use on social media. Why is that significant? Well, a lot of people have lots of different emails for different dating sites, and they're holding their names out to other people. You're going to be able to check out their social media sites, see if they own assets. Do they have a criminal history, bankruptcies, liens, or judgments? Yes, all in one report, and it literally takes just a few minutes. And when you have this background subscription service, you can do as many reports as you desire. You can stop at any time. So whether you want to do 100 searches or you want to do one, go to CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for October 17th of 2024. And first on the docket, say it isn't so. Did the FBI lie to us? I know lie is such a big word. You don't like to use the L word, but you know, when it's just routinely over and over and it becomes so blatant, ladies and gentlemen, you think it's just a blatant lie. You know, maybe an error, I don't know. And you say, what am I talking about? Well, I could be talking about lots of things, but we're going to talk about FBI crime statistics going back to 2022. And back in September of 2023, the FBI reported that the nation's violent crime rate had actually fallen by 2.1%. And this quickly became quite the talking points to counter certain people's claim that crime was on the rise. How convenient. But the FBI has quietly revised those numbers, releasing new data that shows that violent crime increased in 2022 by 4.5%. So instead of dropping, it actually went up. My goodness. Anyway, that new data includes thousands more murders, rapes, robberies, and non-aggravated assaults. Now, the Bureau, which has obviously had some issues lately, did not actually put out a press release regarding their modification of these new crime statistics. But there is a very cryptic reference on the FBI website that states, quote, the 2022 violent crime rate has been updated for the inclusion in the new report in 2023, but there's no mention that the numbers actually increased. One only sees the change by downloading the entire FBI new crime data and comparing it to the file released last year. Wow, you would think that if they were able to update all that data for us, that they'd probably want us to show the errors of their ways so that everybody would have the truth. Apparently not. But you know, you've all heard the saying, right? Lies, damn lies, and statistics, and that's what they try to do. Now, after the FBI released their new crime data, the media jumped all over it, and there were lots of headlines stating that violent crime dropped for a third straight year in 2023, including murder and rape. Well, it's been over 3 weeks since the FBI released the revised data. And guess what? The Bureau's lack of acknowledgement or explaining these significant changes, well, that's concerning researchers. That's right, professors, people that rely upon this data to try and, create new theories to see if things are working in the criminal justice system or not. So the actual changes in crime are quite extensive, and the update for 2022 reports that there were 80,029 more violent crimes in 2021, and there were an additional 1,699 murders, an additional 7,780 rapes, 33,449 robberies, and 37,091 aggravated assaults. So the question, obviously, that begs to be asked is, should the FBI's numbers be believed? Not only for this time period, but forever again. So without the increase, the drop in violent crime in 2023 would have been less than half as large, only 1.6%, instead of the reported drop of nearly 3.5%. Well, the FBI isn't the only government agency that's been known to revise their data. For example, the Bureau of Labor Statistics massively overestimated the number of jobs created during the year that ended in March by 800,000 people. That's not a little revision. That's a huge mistake or a total misrepresentation. So why should the FBI be any different? Anyway, the FBI crime stats revisions reveal how much guesswork apparently goes into the final numbers that is often seized by, obviously, the press and politicians alike. And the FBI doesn't simply count reported crimes. Instead, it offers estimates by extrapolating data from police departments that report only partial year data. And the Bureau also makes estimates for the cities that report no data at all. The FBI's method of generating these estimates changes over time, and it affects the figures and the reports. Now, another problem with the FBI crime data is its reliance on reported crimes. Most crime actually goes unreported. So with only about 45% of violent crimes and 30% of property crimes brought to the police's attention, according to the National Crime Victimization Survey, well, the FBI only tracks reported incidents, and there's obviously a gap, a pretty large gap. So researchers argue that when the media discusses crime rates based upon FBI data, they should clarify that it reflects reported crime only and not the given impressions for the total crimes that are charged. Now, non-reporting of crime doesn't affect all crimes equally. Obviously, non-reporting of murder and motor vehicle theft is relatively rare, and in murder cases, victims can't be overlooked. And for auto theft, insurance claims require police reports. However, it's difficult for us to fully trust even these numbers because the FBI underreported 1,699 murders and 54,216 motor vehicle thefts in 2022. Obviously, that can cast a little doubt on the reliability of the data. Now, although recent attention has focused on the decline in murder rates, even with the revised numbers, the 16.2% drop from 2020 to 2023 still leaves murder rates 9.6 higher than they were pre-COVID. Now, half a century ago, the Department of Justice provided a total crime measure, including both reported and unreported crimes, and the results of the Department's Bureau of Justice Statistics in 2023, their National Crime Victimization Survey, released in mid-September, tell a very different story from the FBI's data. The FBI's 3.5% drop in the reported violent crime rate in 2023, well, the NCVS found a 4.1% increase in the reported violent crime rate. Even with the revised FBI numbers in 2022, the FBI's 4.5% increase pales in comparison to the NCVS's 29.1% increase. And while the FBI claims that serious violent crime has fallen by 5.8%, the NCVS numbers show that total violent crime has risen by 55.4%. Rapes are up by 42%, robbery by 63%, and aggravated assaults by 55% over the last 4 years. Now, since the NCVS started, the largest previous increase over the 3 years was 27% in 2006, so the increase was slightly more than twice as large. Now, the increase shown by the NCVS during the last 3 years are by far the largest percentage increase over the last 3 years, slightly more than doubling the previous record. Now, the FBI's report is somewhat stunning because it doesn't state that violent crime in 2022 was much higher than it had previously reported, nor does it explain why the new rate is so much more higher. And it issued no press release to anybody to try and explain this large revision. Now, obviously, with the media using the 2022 FBI data to tell us for a year that crime was falling, it's a little disappointing that no news articles are correcting the misimpression left by the FBI. Or should I say misinformation? Well, we must see whether the FBI also revises their 2023 numbers. Basically, so what I'm saying there, ladies and gentlemen, is you know as well as I do, during that same time period, things were crazy. It was out of control. We had record number of violent crime cases, and everybody kept saying, oh, things are great, things are rosy. And I'm like, what world are you living in? I've never been as busy in my life. It was chaos. And most people were getting PR bonds during that time period. Things are starting to change a little bit, though. People are starting to realize you can't let crime go. You can't let the minor stuff go because it is literally, you get more of what you tolerate, bottom line. Next, let's talk about the Delphi case. That's right. The attorneys representing Richard Allen in the Delphi murder trial have claimed that cops ignored a hair at the crime scene. And frankly, it's not Mr. Allen's. Now, the attorneys for Mr. Allen made this revelation during a brief mini-opening statement before jury selection got underway there in Allen County, Indiana. Now, for those who don't know, Richard Allen is accused of murdering Delphi teenagers Libby, German, and Abigail, Abby Williams, back in February of 2017 while the girls were out on a hike. So on Tuesday, the attorneys told the court that the DNA evidence was found in Abby Williams' hand, and this was the first time such revelation of that information was made public. Now, while the lawyers did not say who the hair belonged to, they vehemently denied that it belonged to the defendant, Mr. Allen. Now, Mr. Allen is charged with 4 counts of murder in connection with the girls' deaths, with the prosecutor saying an unspent bullet that was found at the scene was matched to a gun owned by Mr. Allen. Now, to ensure the jury pool and the local outraged jurors are being selected from Allen County, which is about 100 miles from where the murders took place. Now, the prosecutors have also announced that they want to omit a sketch taken in the early days of the investigation, believing that those witnesses could not identify Mr. Allen. The prosecutor has argued in a motion hearing that the composite sketches released in 2017 and 2019 were not relevant to the identification of Mr. Allen. Now, Allen's defense is expected to use the sketches to poke holes in the witnesses' account of what took place, their reliability. And the prosecutors, guess what? They're saying the drawings weren't used to catch Mr. Allen, so therefore they're completely irrelevant. Now, at the time, the sketches based on witnesses' recollections were intended to generate tips, but they ultimately didn't lead to Mr. Allen's arrest. The prosecutors also said the witnesses who assisted in creating the sketches would not be able to positively ID Mr. Allen in court. Like I said, the 2017 sketch depicts a man with a beard, mustache, a hoodie, and a fiddler cap, while the 2019 sketch showed a significantly younger man with curly hair. Now, these recent developments comes after the judge, Francis Seagal, ruled that the jury could not hear the defense's theory that the girls were the victims of an Odinist cult ritual killing. Like I said, Judge Gull decided to exclude the theory on grounds that there was no evidence to support it and it would simply confuse the jury. And so other than leaks from inside the investigation, very little information has been made public about this case until earlier this year during motions hearings. Now, the court did hear in the motions hearings that the girls were found with their throats cut, branches laid on top of their remains, and Abby's body wearing Libby's clothes. The two had set out on the Monon High Bridge Trail back in Delphi, Indiana at about 1:35 p.m., and Libby posted a photo at 2:07 p.m. Of Abby walking along the bridge. She posted the image on her friends standing on the trail's abandoned Monon High Bridge to Snapchat. Now, police believe they were kidnapped roughly about 2:14 p.m. and killed within about 18 minutes after that. The prosecution says that Allen's confessed to the murder over 60 times. Needless to say, the defense says not true. This is a question of fact for the jury. Now, back on February 15th, 2017, 2 days after the murders, police released what was to become the most defining image of the case. A grainy video clip from Libby's phone captured a man walking on the bridge, known only as Bridge Guy, who is believed to be connected with the murders. Now, Bridge Guy was dressed in jeans. He had on a blue jacket and a cap. And he was seen walking on the bridge on which, moments earlier, Abby had posed for her picture. He walked with his head down and instructed the girls, quote, "guys down the hill," end quote. One of the teens could be heard saying "gun" as he approached. Now, it later emerged that Allen had been interviewed by police immediately after the killings back in 2017, but somehow that interview, overlooked by the FBI, their file clerk, and it only came to light when a new investigator went back through and looked at everything in the case, where they found the missing statement or interview with Mr. Allen. And in that interview, it was significant because Allen admitted to the officers who met with him that day that he had actually been on the trail and was wearing clothes consistent to what was being worn by the Bridge Guy. Now, after his arrest, Allen was transferred from the Carroll County Jail to the Westerville Correctional Facility, where he was held in isolation. Now, Allen, who his attorneys argue had been showing signs of grave mental illness, is alleged to also have confessed more than 60 times during telephone calls to his wife and his mother. Those are certainly going to be some interesting calls to hear in court. Now, according to the Indiana State Police Detective, Brian Harshman, Allen gave specific details about the crimes and what he claimed was his motive. So after jury selection ends, Allen's trial is set to begin probably on Friday. Now, he faces up to 130 years in prison, and he has pled not guilty, and he's entitled to that presumption of innocence, unless and until a jury finds him guilty. So on Thursday, the judge is set to hear a motion from the prosecutors to prohibit the jury from seeing these two sketches that I talked about earlier. Now, the prosecutors requested that the composite sketches not be admitted as evidence during the trial, and the prosecutors alleged that the sketches are not relevant and they would only confuse or mislead the jury. Kind of interesting, because that's what the police were putting out to say this is what we think may be the guy that may be involved. You would think that that would become some relevance, particularly as it relates to the investigation that the police engaged in. Anyway, the prosecutor told the court that the sketches should not be admitted because a composite sketch is not relevant. Admissions would result in undue prejudice, confuse or mislead the jury, or leave impermissible hearsay, and the witnesses who participated in the preparation of the sketches are not presented by the state for the purpose of in-court identification, which means they're not going to have the witness come in and say, when asked the question by the prosecutor at the big moment, do you see the man that's in that sketch here in the courtroom today? And the witness will look around and point to the person and say, that is the man in the sketch. The prosecutors aren't going to do that because the witnesses can't identify him. The judge will also consider a request from the defense to visit the crime scene there at the Monon High Bridge. Now, that hearing is set for Thursday at the Allen County Courthouse in Fort Wayne. Now, Judge Gull will travel to the Carroll County Courthouse this afternoon to swear in the jury. Like I said, the trial is scheduled to begin Friday at the Carroll County Courthouse in Delphi, Indiana. If anyone is going to happen to be there and they would like to, give us some in-depth analysis as to what is taking place, how people are actually coming across on the witness stand, be greatly appreciated. Send it to Frank at ReichLawFirm.com. We'll hook you up. Maybe we can help with a small stipend or something. We'll see how it goes. Next, the Alec Murdaugh case is finally coming to a close, at least some of the civil suits. So Alec Murdaugh has settled a lawsuit brought by the family of the teen killed in the boat crash involving Alec Murdaugh's younger son that prosecutors said, basically started the South Carolina attorney's downfall, which ultimately led him to kill his son and his wife, all in regards to the wrecked boat. So the Beach families have already received more than $15 million for a settlement from the Parker's Kitchen chain or convenience stores and others, as well as lawsuits with a family that held an oyster roast the group on the boat attended, a bar that served Paul Murdaugh liquor just moments before the crash, and Paul Murdaugh's older brother, Buster, whose ID he used to buy beer. Well, a snag with the insurer on the boat, Progressive Insurance, prevented the entire case from being settled last summer. And according to the court records, Progressive wouldn't pay until Alec Murdaugh was dropped as a defendant in the Beach family lawsuit. And once the special receiver assured that all of Alec Murdaugh's assets have been paid out, the Beach family finally agreed to end the case, and the insurer paid $500,000. The judge signed that order dismissing the case. Now, other passengers on the boat who were injured have also settled with their lawsuits against Alec Murdaugh and others involved in the crash. And, well, obviously, Alec Murdaugh is serving a life sentence, multiple life sentence for the death of his wife Maggie and son Paul there in Colleton County. Of course, he's denied killing them, and that case is on appeal. Now, if the murder cases are overturned, he'll remain in prison. Why? Well, because Murdaugh admitted to stealing some $12 million from the family law firm and from his other clients. And, he's got both a state and federal sentence where he will serve. The federal sentence is 40 years. Now, the prosecutor said one of the last things Murdaugh did before heading home the night of the killing was to work on financial statements he would have had to present in court in regards to the Beach lawsuit scheduled 3 days later. It's alleged that Murdaugh feared an investigation into those financial statements, which show that he stole millions of dollars from his client's law firm, from his clients and his law firm and his partners. And prosecutors said that the killings were a sinister, methodical plan to buy time to straighten out his financial situation and slow down the wrongful death lawsuit, which obviously has involved Miss Mallory Beach. Like I said, the lawsuit, known in the true crime world as the Boat Case, showed both the family's longtime influence over the Hampton County, where they controlled much of the criminal and civil court activity there in the Low Country. So the Alec Murdaugh saga is coming to, hopefully a close, unless, of course, he gets a new trial, which he might actually get. I think the judge let in too much 404B evidence. I think it was a little too much over the top, and I really think we're going to get a do-over. I really do. I think we're going to get a do-over in that particular case. Even though he's a scumbag, he's been found guilty, killing his wife and kids, stealing money from his law firm and his clients, he's still entitled to a fair trial, no matter what a big scumbag he is. Speaking of scumbags, though, let's talk about the former Las Vegas politician convicted of killing an investigative journalist who had written critical stories about him. Well, he told the judge yesterday that he was innocent, and the judge said, well, Mr. Innocent Man, you're going to go spend at least 28 years behind bars before being eligible for release. Now, the judge also invoked a sentencing enhancement to add 8 years to the minimum 20 years to life sentence in the case of Robert Tellis, who was found guilty of killing the Las Vegas Review-Journal reporter, Jeff German, outside of Mr. German's home back on Labor Day of 2022. Now, German spent 44 years covering crime, courts, and corruption in Las Vegas, and at the time German's death, Tellis was the elected administrator of the Clark County office that handles unclaimed estate and probate property cases. Now, Tellis, like I said, spoke at the sentencing hearing on Wednesday and denied any responsibility for German's death. Well, that's frankly a good thing. That's what he should do when the case is going to be appealed. Now, I don't think this one is going to be reversed in any way. I think Mr. Tellis, well, he'll probably spend the rest of his life in prison. Next, the Gilgo Beach case is going to come down to some new DNA technology. Interesting. That's right. The case of accused Long Island serial killer Rex Heuermann is headed for a showdown over novel DNA testing the prosecutors say connects Heuermann to the murder of 6 women. And needless to say, Heuermann's defense team says that is magical conjecture. Now, Rex Heuermann appeared in a New York courtroom Wednesday to discuss the status of discovery and other evidentiary matters that needs to be resolved before this case can get headed down the trial road. Now, he appeared in a suit and had his handcuffs on, and the former architect stood silent during the 5-minute courtroom proceeding while the attorneys argued with the judge. Now, Heuermann's lawyer, Mr. Michael Brown, told the judge that he's waiting until he receives all evidence from the prosecutors before he can file any motions. And in particular, he's going to file a Fry motion. and that's to determine if the DNA scientific evidence that's being used is scientifically valid. Now, there used to be Fry hearings all the time on DNA 25 years ago. Now it's just been found to be reliable, and the evidence comes in if the proper foundation is laid. You don't have to have a hearing to see if it is some unique and novel DNA evidence. So we're going to have to wait and see what the attorneys are arguing about. Needless to say, the district attorney had a different spin on the situation, and they said that their office won't object to the hearing because they see this as an opportunity to prove the admissibility of the testing of the DNA, which the prosecutor says has not been used in New York criminal trial before this particular case. It's like everything. It's always getting just a little bit better. Before, you needed a lot of DNA, even though a lot was very minute amount, but now it's even less. It's amazing the small amount of DNA that they can do. Then they basically copy it to make it bigger and bigger so they can create the profile to see if it is in fact a defendant, or to exclude the defendant from that particular profile that's been made. Anyway, the judge told the prosecutors to complete discovery no later than December 17th. The judge also urged the parties to try and reach an agreement on what would be debated at this Fry hearing to avoid the need for motions and litigating on the particular issues. Judges are always wanting everybody to get along. The other parties are saying, hey, let's have a hearing. Anyway, prosecutors said in Wednesday's hearing that they have given the defense all the evidence related to the DNA testing in this case, including records from the Suffolk County Crime Lab and a private lab that provided the contested results, allegedly linking Huerman to the victims. They have also said that they have handed over 99.9% of all raw data from every electronic piece of evidence collected from 400 devices. Now, after the hearing, both sides addressed the media, speaking for longer than the hearing took place inside. The prosecutor called the December discovery deadline ambitious, given the volume of evidence collected over the past 3 decades. And the prosecutor spoke at length about funding his office needed to comply with the discovery obligations, drawing attention to forfeiture funds that he said the federal government has frozen as part of a DOJ investigation. So in other words, the prosecutor doesn't have enough money to compile and get to the defense all of the relevant discovery in the case. Anyway, in addition to the hearing, Huerman's lawyer said that he intends to pursue a venue change to sever charges relating to 2 victims who went missing back in the 90s. The attorneys accused the Suffolk County prosecutors of poisoning the jury pool with inflammatory comments about Huerman's alleged guilt and demeanor. Huerman's attorney spoke at length about the importance of the Fry hearing, describing that the contested DNA results as magical evidence that was generated by a for-profit lab on the West Coast after the Suffolk County Crime Lab was unable to link Huerman to the victims using other forms of DNA testing. Otherwise, the attorneys for Mr. Huerman told reporters that Huerman was eager for his day in court. In the meantime, though, Mr. Huerman remains in isolation at the Suffolk County Jail for his safety, even though Huerman doesn't think he needs to be in solitary confinement. Next on the docket, Karen Reed. That's right, get some help from the ACLU? That's right. For those who don't know, Karen Reed faces a number of allegations that involve leaving her boyfriend, John O'Keefe, to die in the snow after hitting him with a car after a night of drinking back in 2022. Now, her first trial ended in mistrial in July of this year after the jury said that they were unable to reach a unanimous verdict. Then in the weeks and months following the mistrial, various jurors came forward and said that they, in fact, were only deadlocked on 1 count of manslaughter, and they had actually agreed to acquit Miss Reed on the second-degree murder and leaving the scene of the deadly accident. Now, those claims from the jurors have led the defense to ask for a dismissal of the case, saying that Miss Reed should be protected by double jeopardy because the jury was ready to acquit her. And the Massachusetts highest court, the Judicial Supreme Court, has agreed to hear the case with a full panel of judges. On Wednesday, prosecutors filed their briefs, which argued that the jurors' post-mistrial claims are irrelevant and do not constitute acquittals. In the brief, they stated that the notes that the jury sent out during their deliberations which explicitly said that the panel was starkly divided over the charges, implies that there was in fact no consensus. Prosecutors are also arguing that until the final verdict form is signed, jurors are free to change their minds, and the messages from individuals following the trial never indicated when, during the days of deliberation, the jury had actually reached their agreements. Like I said, guess what? The ACLU, the American Civil Liberties Union of Massachusetts, the local chapter, so to speak, stepped in with the case and with an amicus brief filed in support of Reed's appeal. Now, while the ACLU there of Massachusetts makes it clear they have no position on Miss Reed's guilt or innocence, they are arguing that the judge presiding over the trial screwed this thing up by not holding an evidentiary hearing to determine whether the jurors had reached a verdict. Prosecutors said in their briefs that even the different statements from the 5 jurors who came forward don't align with the notes from Juror C, saying that the group was unanimous to acquit on a single charge. Apparently, even the 5 purported jurors said nothing of the 7 other jurors were not of one mind. Anyway, the jurors in this case have not been publicly identified, and their names have been sealed by the judge, citing security concerns. At least one juror petitioned the court to remain anonymous, citing harassment and fears of their safety. Now, the highest court there in Massachusetts will hear an oral argument in Reed's case on November 6th. Her case is currently set for a retrial on January 25th, and I think that she's going to be tried on all of the charges. I am of the position that everybody screwed up in this particular case. The judge should have inquired further. The prosecution and the defense could have asked, hey, judge, why don't you ask the jurors if they have reached a decision on any of the charges. But the judge took the jurors' notes at face value and said, we were helplessly divided, and therefore said, let's just declare a mistrial, which which the defense, that's right, Miss Reed's attorneys had asked for a mistrial previously. They want their cake and eat it too in this particular case. And I know it sometimes pains me, but I got to believe, I think the prosecution's right in this particular instance. They all screwed up. Go back to square one. And if the prosecution thinks that it's so unfair, they can dismiss those counts. But I don't think they're going to do it. They're going back for round 2. And the second trial never, ever, ever helps the defense in any way. In fact, it always helps the prosecution. I cannot think of a single case that I have tried that mistried, unless it mistried again, where the defense prevailed. Next, charges for a missing woman whose remains have never been found. Well, a man and woman have been arrested in the case of the missing woman by the name of Kimberly Bell, who went missing back in 2019. That's according to the Douglas County Sheriff's Office here in Colorado. Now, the Sheriff's Office held a news conference the other day announcing the arrests of Javier Alex Martel and Jennifer Bremer for Ms. Bell's murder. Now, Bremer is charged with 1 count of accessory to crime and 1 count of identity theft, both of which are felonies. And Martel is charged with 2 counts of first-degree murder. Now, the Douglas County Sheriff's Office said that Bell was reported missing back in August of 2019 by her sister. And Bell had been living with her sister in Franktown, Colorado, and had stopped showing up for work back in July of 2019. Bell's case was turned over to a cold case unit back in 2021. Now, according to witness statements, the suspects, Martel and Brenner, were known to Bell and were in her rental car on July 22, 2019. And the indictment alleges that Bremer said that she and Bell worked and lived together for a time, and Martel was Brenner's boyfriend at the time. Now, according to the indictment, Martel and Bremer were driving around with Bell after she called them to shop for a Jeep since her previous car had been totaled. And after driving around for a bit, they went back to the area near Bell's hotel, near the Lincoln Station RTD Park and Ride, the light rail station. And from there, it's alleged that Martel became enraged with Bell, pulled out of the driver's seat and into the back seat with him choking her. Now, Martel then told Brenner to get into the driver's seat and drive. Martel continued to choke Bell until she was dead, according to one of the witnesses. Now, in the indictment, Bremer testified that she asked Martel if he killed her, and he said, I guess I did. Now, Martel and Brenner then drove to various locations around the Denver area with Bell's body in the backseat of the car, including a Home Depot where several items, including an axe, were purchased. Now, while driving around, Martell told Bremer to drive to a gas station, and Bremer then used Bell's credit card to pay for the gas to put in Bell's rental car, according to that testimony. Anyway, the pair then drove to a remote location near Estes Park, Colorado, where Martell dismembered Miss Bell's body, according to the indictment. And after Martell's body was put into trash bags and then left them in dumpsters near a veterinary clinic. Now, according to the grand jury indictment, Google location data would paint a picture for investigators about Bell's location that night. Her account history also included searches like take a tracking system out of a Ford Focus and does phone ping location if off. Bell's body has not been found. They said that they've never had a case quite like this there in Douglas County, according to the sheriff. And they said they hope to break the case and they'll start giving the Bell family some answers. And obviously their sympathies go out to the family. The family has also thanked the families or the sheriff's department for working on this case. Now, Mr. Martell is in custody at the Douglas County Detention Center on a $10 million cash-only bond, which means he'll remain there until his trial, when more than likely he's going to be convicted. Now, the sheriff said despite the indictment, the investigation is still ongoing, and he urged anyone who knew Ms. Bell, Martell, or Brenner, anything about what happened that night in July, to contact the Douglas County Cold Case Unit. All right, should this woman get the death penalty? Let me know in the comments below. So, Tyshell Elise Martin is charged with first-degree murder, also charged with aggravated manslaughter of a child and aggravated child abuse in the death of Jamaria Sessions in Monteverde, Florida, which is about 25 miles west of Orlando. Now, investigators obtained video from inside the home of the girl's savage beating, allegedly at Martin's hands. Now, an autopsy determined that Jamaria died of blunt force injuries to the head, torso, and extremities, and thermal injury to the right foot. That means a burn. Anyway, the medical examiner ruled the cause of death a homicide, and the Florida's 5th Judicial Circuit filed a motion stating their intent to seek the death penalty. Now, in order to impose the death penalty, the state has to establish aggravating circumstances. And in this case, they say that in Miss Martin's case, they can prove that. For example, under the Florida state death penalty case, one of the aggravators are that the defendant was engaged in or was an accomplice in the commission of or attempt to commit an aggravated child abuse. There's number one. Second, that capital felony was especially heinous, atrocious, and cruel. Number two, the capital felony was a homicide that was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. There's three. And the victim of the capital felony was a person less than 12 years of age. There's number four. And the victim of the capital felony was particularly vulnerable because the defendant stood in a position of familial or custodial authority over the victim. All five aggravators. Anyway, the Lake County Sheriff deputies, how this case got started, responded to the home on June 17th. Paramedics found Jamaria naked with a significant number of abrasions, small punctures, burns, possible bite marks, and bruising covering her body in all various stages of healing. Now, Martin said the family was supposed to take a flight that morning to California because they were going to go on vacation. And she told the police that she tried to wake up Jamaria. She was unresponsive and cold to the touch. Anyway, detectives obtained nearly 3,000 videos from inside and outside the home and ultimately focused on 6 videos that were taken shortly before the hours of midnight on June 15th. They allegedly showed that Jamaria was being viciously attacked by the dog's pet, 103-pound male Rottweiler. Martin is seen holding the dog's leash, encouraging the dog to bite Jamaria as she's lying on the floor just outside of the camera's view. The next clip shows Jamaria Sessions staggering nude and disheveled, and this is all according to the arrest affidavit as well. And Jamaria's hair, previously in a partial bun, was now messy, and her extensions were falling out of her hair. It appears that the dog had bitten the child's head, pulled out her hair at the commands of Tyshell Martin. Now, Miss Martin then allegedly forced the girl to stand in place with her arms held up in the air. Jamaria appeared to be disoriented and started to sway, which caused Martin to kick her, according to the deputies, where the girl ultimately fell to the ground. Now, once the child was there on the ground, moaning in pain, Miss Martin continued to kick her hip and eventually her stomach with full force. Now, when the child did not get up, Miss Martin then grabbed the child by her hair, pulled her across the floor with minimal resistance by Jamaria, apparently, who appeared to be completely disoriented and motionless. Now, according to the affidavit, Martin continued to beat Jamaria and said something to the effects of, "I'm fixin' to kill her." Now, detectives also learned that Miss Martin apparently uses exercises, including prolonged wall sits, running in place with her hands up, and running on a treadmill as a form of punishment. This is all according to the arrest affidavit. Now, when Miss Martin would also allegedly kick, punch, and pinch the young girl. Now, Jamaria's father, LoJohn Sessions, is also charged with aggravated manslaughter. Martin and Sessions are in the Lake County Jail without bond. Now, we'll give them the presumption of innocence, ladies and gentlemen, but I can see why the prosecutors are saying we've met the 5 aggravating factors homicide case in this particular case. That wasn't an accidental situation. That was not, oh my gosh, I lost my temper and I can't believe I did something horrible to the child. That was torture, ladies and gentlemen. That was torture. Next on the docket, this day in legal history. Back on October 17th, 1919, Congress passed the Volstead Act over President Woodrow Wilson's veto. Now, the Volstead Act provided for the enforcement of the 18th Amendment, which had established prohibition in the United States. The law defined intoxicating liquors and laid the groundwork for federal enforcement, leading to a decade-long era of legal challenges and illicit alcohol trade until prohibition was repealed by the 21st Amendment back in 1933. And on October 17th, 2006, President George W. Bush signed the Military Commissions Act into law. This legislation, obviously by Congress, established procedures for prosecuting terrorism suspects and had implications for the rights of detainees held at Guantanamo Bay. It allowed for military tribunals and restricted habeas corpus rights for certain non-citizen detainees, sparking significant legal debate and ultimately many, many Supreme Court challenges. And finally, our dumb criminal of the day. This guy, when I heard about this, I like, well, that's just cruel. But this guy's dumb and cruel. But he still fit the category for dumb enough today. Anyway, the Florida dog owner who left his dog tied to a fence post in floodwaters on the side of a highway as Hurricane Milton was heading towards Florida last week has been arrested. Please meet Giovanni Aldame Garcia. He was arrested Monday and charged with aggravated animal cruelty, a Class 3 felony. Now, apparently Garcia admitted to leaving the dog, which was a bull terrier, on Interstate 25 as the hurricane was coming on shore. The 23-year-old told police he left the dog named Jumbo because he couldn't find anyone to pick the dog up. Like I said, he's charged with a felony, faces up to 5 years in prison. And the dog was brought to a local vet where he was examined and treated for any injuries that he had. And apparently the bull terrier is going to a foster home in Tallahassee. And the name has been changed to Trooper due to how much the dog has been through and to honor the trooper who saved him from the storm. That's just dumb and cruel. Listen, ladies and gentlemen. You don't like your kids, you don't like your dogs. I know it sounds terrible, but you can rehome them to people that will actually care for them. You don't have to torture kids and animals. That's all we have for you today. Thanks, ladies and gentlemen. Obviously, I apologize for not having a show yesterday. It was a travel day after a court date some 5 hours away, and we had to do the worst thing ever, which was drive. Just kidding. It was almost kind of relaxing. Anyway, have a wonderful day. We'll see you next time on Crime Talk. And never forget, the Constitution matters.